Thank you very much for your argument.
Thank you.
Next case is Green versus Williams.
Good morning, Your Honors. May it please the Court, my name is Julius Williams, and I represent the appellant, William Green, Sr., and I would like to reserve 5 minutes, please. The facts in this case are pretty straightforward. The Department of Revenue issued an intent to levy that was sent to an address of 324 West Ella J. Gilmore Street in Apopka, Florida. It was addressed to William L. Green. Okay. There was no indication of whether it was senior or junior. And this is the address that the appellant resides. Pursuant to the notice of intent to levy, William Green Sr. filed a petition in the existing circuit court case claiming that the funds in the Fifth Third Bank account that the Department of Revenue intended to levy belonged to him. We, after hearing, the trial judge granted the Department of Revenue's motion to dismiss and entered a final order of dismissal, and we filed an appeal. The only question that's before this court is whether Mr. William Green Sr. was entitled to an evidentiary hearing to establish his ownership to the funds that were in this account. And we're basically dealing with statute 409.25656. And there's regulations that were promulgated pursuant to that statute. And taking the statute and the regulations together, it indicates that if there is a where the regulations state, it says that it first says an action may be brought to contest the notice of intent to levy, okay, which Mr. William Green Sr. did. The regulations also states that when a levy action is against an obligor's joint-owned assets, the department shall provide the same notice and opportunity for a hearing to a joint owner as the department provides to the obligor.
Isn't your problem that the trial court found that you were not a joint owner?
Well, I don't think that's what the trial court found. I think that the trial court really did not indicate in its order what reasoning it is.
Well, if I understand, and maybe I'm wrong on this, but as I understand what the dispute was, I guess Mr. Green Sr. and Mr. Green Sr. claims that the money in the account is his, although the account was apparently in Mr. Green Jr.'s name. Is that correct?
That's correct, it is. And
so apparently the trial court concluded, based upon the argument of the department, that the fact that the account was solely in the name of Green Jr. was conclusive and irrebuttable, and that you were not entitled to a hearing to show that although it may be in his name, it's my money. I mean, is that kind of what happened?
Well, as to the reasoning of the trial court, I really can't say because the trial court didn't say, but I think that's part of the reason that
your position is that the fact that the account is in the name of Green Jr. perhaps creates a presumption that he owns it, but it isn't an irrebuttable presumption, and you're entitled to a hearing to prove to the contrary.
That's correct, Your Honor.
I mean, that's your position in a sentence, isn't it?
That's it. I think we're entitled, all we were asking for was an evidentiary hearing to prove that the funds belong to William Green Sr. We'd indicated in our petition that he filed claiming the funds, that the monies in the account came from a reverse mortgage. And we just basically wanted to come in and says, let us be able to prove that what the source of the money was, and it was his money.
Well, the department says, and frankly I have some sympathy with this, we know that from something the trial court said, that he thought his task was to figure out whether you were a joint owner for purposes of this particular statute. And he concluded by the outcome that you were not. Well, and your opponent says, look, they have a perfect remedy under Chapter 77. That's where you deal with third-party claims, and you got to have an affidavit. And you come in and you say, I don't have to do this under 77. I can do it under this statute because there's a procedure that's allowed for this to be done. The problem is that this procedure is for joint owners. And the more I read this, the more I'm convinced that joint owner means somebody who's actually on the account. Because if you're not on the account and you don't file an affidavit, you haven't done what Florida law requires in order to be able to be entitled to that evidentiary hearing.
Well, I disagree, and here's the reason why. Chapter 77 says sets out the procedure that you're supposed to follow, and it says that you have to file an affidavit or verified complaint. This particular statute nowhere says that you are required to file any kind of verified complaint.
No, but it also says you have to be a joint owner.
Okay.
And so what that suggests to me is that you actually have to be on the account.
Your Honor, if I may, under the regulation it says joint owner means a person who co-owns an asset. It does not say that you have to be on the account.
I thought you claimed that you were the only owner of the asset. And
that's true. That we.
I mean, you don't claim to be a co-owner.
Well, it doesn't. We did say that that the funds in the account were William Green Sr.'s money. It came from a mortgage.
Does it really make any difference where the money came from?
Well, no, I don't think it makes any difference where the money came from, but that was just in terms of an evidentiary hearing.
It's not dispositive. The fact that the money came from the dad doesn't mean that the dad retained ownership of it, right? It could have been a gift, right?
But I would agree, it could have been a gift, but you can't decide that unless you have an evidentiary hearing.
He kind of relinquished every aspect of ownership. I mean, if property is a bundle of sticks, if his rights in the money is a bundle of sticks, he gave up every stick in the bundle by giving it to his son for his son to put it in an account without him having any access to it anymore, right?
No, sir.
Which stick in the bundle did he keep?
Well, Yanni, that simply because I give X, let's say I give my sister some money and I says, hold this money for me, doesn't necessarily mean that it's a gift to her.
Yeah, well, that's the hold this money for me. That's a trust. There's no allegation here that he ever said, hold this money for me.
Well, no, there isn't, because the statute as it sets out basically says if does not say that you have to claim that the person is holding it in trust for you. You just have to claim ownership of the funds that the department has levied upon.
But there's the rub. The account is solely in Junior's name. Junior is the only signatory. Junior is the one that has the right of control. And in the absence of some allegation that shows why your client has some claim on the money, I don't even see how he could claim to be a joint owner or the sole owner.
Well, Your Honor, I think between strangers, yes. Between people who are relatives, not necessarily. I mean, it just, parents and children and siblings do this type of thing. I mean, it's not something that, you know, if you saw a lawyer first, you would do, but then they don't. But that should not negate Williams Green Sr.'s right to come in and say, in response to the department's levy, this is, money belongs to me.
How'd the money get in the account? Do we know that? Do we know how the money got in the account? I guess the father got a check from the mortgage company.
And it was.
Did he endorse it over to the son, or what did he do?
I'm not absolutely sure how that came about, but that was how it got into the account.
Was the son the payee on the check from the mortgage company, or was the dad the payee?
The dad was the payee. So I think it's basic under the statute and under, I believe, under due process that Mr. William Green Sr. should have an opportunity to come in and at least prove that he owns these funds that are in this account.
Well, I mean, there's no way for the department to contradict if the dad and the son come in and say, oh no, even though we put it in the account, and even though it's in the son's sole name, the son was the sole signatory on the account, we both intended, so they're going to say that, right? We both intended that it was dad's money, right? They're going to say that. How does the department refute that?
Well, you know, I don't know that the department could refute it or they could not. But see, that's an issue for the trial judge to determine based on the credibility of the witnesses. But you can't get there if you don't have an evidentiary hearing. And that's been our position, to deny Mr. Green Sr. the opportunity to come in and say, these are mine. I mean, if the trial judge says, well, I don't think your testimony is credible, then that's the decision for the trial judge to make. But to deny any opportunity at all to come in and at least put on proof.
There's really no theoretical evidence to refute what is presumably they're going to say, both the father and son are going to say that it's dad's money. So that the department doesn't really have any evidence to refute that other than the way the money is listed in the account.
Well, that's something to take into consideration by the trial judge. But I don't think that's.
The trial judge actually have to hear the testimony to just conclude that
No.
you can't defeat the way under these circumstances you can't defeat the ownership as it's set in the bank records. I mean, isn't that a presumption that trial judge can just consider without actually hearing the testimony?
No, sir, I don't think so.
Could the department get a summary judgment in this case?
I don't think they could get a summary judgment in this case.
So I think any time that we have this circumstance, so it doesn't necessarily have to be a father and son. Judge Griffin could have said it was my money in the account, right? And then she would have had the right to be heard at the proceeding, right?
Well, she could. I would agree with that.
But you have to, unless you're going to take an inconsistent position.
No, I'm not going to take
Anybody can come in at any time and just say it's my money in the account, and the trial judge's got to give them an evidentiary hearing.
I would agree.
Okay.
But I think that's the reason for having an evidentiary hearing. I would agree with you. Some people may come in and they cannot say in good faith that they are the owners. But I think that's for the trial judge to sort out. one of the things that the trial judge can look at is how the account is set up. That's on one side. Then you take the testimony on the other side and you weigh the two. That's what the entire evidentiary hearing is all about.
And there's no impediment to you having an evidentiary hearing if you file an affidavit. I mean, you have a perfect remedy. All you have to do is file an affidavit and you get your evidentiary hearing.
I would agree that if had we filed an affidavit or had we filed a verified complaint, that would not have been an impediment to an evidentiary hearing. But this particular statute does not require it.
If you're a joint owner.
I don't think whether you were joint owner or you claim to be the owner. I think that, see, the thing about...
It says joint owner. It says a joint owner may contest.
Okay, it says joint owner may contest.
So you have to be a joint owner in order to qualify under the statute that you're traveling under. And the trial judge said, that's my job, I got to figure out if they're a joint owner, and he ruled against you.
Well, you can't determine whether you really can't determine whether there was a joint owner unless you have an evidentiary hearing.
Or unless you've got adequate allegations in the complaint. And that's the problem here, that there aren't adequate allegations in the complaint. It says where the money came from, but it doesn't explain how the money got into that account and under the sole control of Mr. Green. Let's hear from opposing counsel. You've got about 4 minutes left. We've used a lot of your time.
Thank you.
May it please the Court, my name is Bill Branch. I'm an Assistant Attorney General with the Florida Attorney General's Office on behalf of the Appalachia Department of Revenue. Judge Griffin basically summarized my argument. The Department of Revenue is not saying that Mr. Williams doesn't have a remedy. He has a remedy under 7716, which...
Well, does he have a remedy under the statute that he's claiming a remedy under?
No, sir. He's not a joint owner. And as...
Well, I mean, how do we know that he's not a joint owner?
My argument was based on the legal definition generally you see with regard to joint owners of bank accounts. Your name is on the account, and his name's not on the account.
So if the son stole the money from the dad, put it in an account in the son's name, so that the dad never relinquished any of the sticks in the bundle, he can't come in and avail himself of that remedy under that statute.
Not under 409, Your Honor, but he can under 7716, which is entitled Claims by Third Persons to Garnishee Property. And simply in this case, if he had filed a verified complaint or petition and the judge had ruled the same way and said you're not entitled to have an evidentiary hearing, frankly, I would have worked with opposing counsel.
Shouldn't we construe the statute literally? And the statute doesn't, it defines joint owner, right?
I don't believe it defines joint owner.
I thought counsel read the definition of joint owner in there.
I apologize, but I will find that very quickly.
It's in the rule, isn't it?
Oh, it's under the rule, Your Honor. And I apologize for not knowing that directly.
The rule just says that, as I recall his quotation, the rule just says that a joint owner is somebody that...
A joint owner means a person who co-owns an asset with the
co-owns. I mean, that doesn't tell me anything. It doesn't say that a joint owner is someone who is listed as a joint owner on the account. That would be simple to do if they wanted to do that.
It doesn't, Your Honor.
It just says a co-owner.
I would concede that. However, I think in terms of reading that definition or making sense out of the definition, I think it's reasonable to consider it in light of joint bank accounts, how they're usually considered. If your name's on the account, you're a joint owner. Might be a right of survivorship, which didn't occur in here. Well, as far as we know.
Does that create an irrebuttable presumption? If
I have
or
a
is it a
problem.
rebuttable presumption?
I don't believe it's irrebuttable. I think there's... The department is not trying to keep money that rightfully belongs to Mr. Williams. He has a remedy, and it's under 7716. It's real simple. He files the affidavit, he's entitled to an evidentiary hearing, and I don't think it needs to go any further than that.
So is it your position that if we were to affirm the order of the trial court, is he still within his rights at this point to file a Chapter 77 proceeding?
I don't think it's res judicata. I think it's a ruling under 409. It was never, Chapter 70 or 7716 was never addressed. It was never raised. I think he has a remedy under 7716, and that's the proper way to
Is that remedy have a time limit on it?
No, sir, it doesn't. It doesn't have any time frame. 409, it's either under the rule or 409. The challenge has to be made within 21 days. But that's by the obligor. I don't believe that's the time limit that's on any joint owner. But again, I don't believe joint owner applies in this particular case. He does have a remedy. Frankly, to answer your question, if the son and the father come in and say, it's my dad's money, what does the department do? There's going to be some discovery done. I would anticipate to find the check that was produced that went into the account to kind of match up monies. And again, I think as counsel stated, it's an issue for the judge to listen to the witnesses and determine credibility and go from there, just like any other evidentiary hearing would occur.
The other problem I have with all of this is procedural. It seems to me more efficient in a case like this if Mr. Green Sr. could proceed in the same case, rather than having to file a separate Chapter 77 lawsuit. It makes more sense that it be done in this case.
Well, the problem, though, in this particular case under these facts is a non-party just can't come in and file something in an action. There was no petition or no motion to intervene to establish why he should be allowed to participate in the cases. And this is a child support case, so to intervene as a party, then clearly if he's allowed to do that, it would have to be limited solely to this, for the purposes of intervention being to challenge the levy on that.
Well, money. I mean, there wouldn't be an impediment if he were a joint owner, because there's a procedure for him to come in if he's a joint owner. And to the extent that he claims that he has, I mean, we know that Green Jr. has bare legal title to the money.
Yes, ma'am.
And we also have a pleading, though while defective, does allege affirmatively that Green Sr. Has equitable title. So in that sense, are they not joint owners?
I would argue no. I go back to the way courts look at bank accounts, and if your name's on the account, then you're a joint owner. I think that's different. Joint ownership, I believe, is different from having an equitable interest.
Well, if you define a joint owner as a co-owner, then we get closer, don't we?
To the equitable interest?
Yeah. And the reg does define a joint owner as a co-owner.
That's correct.
So we're getting pretty close. And it makes more sense to do it in this proceeding. Otherwise, we've got some guy off over here trying to assert his claim while DOR in a different place is trying as fast as it can to get the money for the benefit of the family, for the children. So the notion that those two things would be going simultaneously, or even that Mr. Green Sr. might not get there in time, is problematic to me. The only problem then that's left in my brain is the fact that he purports to do this without filing an affidavit attesting to the fact that he actually owns the money. It seems to me that ought to be a requirement. He can't take advantage of this particular statute unless he does the minimal, which is to say under oath, subject to penalty of perjury, it's my money.
And I agree, Your Honor, and frankly, I think it's a very simple procedure to be able to, and I agree with you, it would appear to be more efficient to do this all within the child support case, as opposed to him having a separate proceeding and them tracking each other. He can file a petition, he can file a motion to intervene, stating forth that he's intervening for the limited purposes only of addressing his claim of right to the money in the bank account.
Do you see any impediment to him moving to intervene in the particular circuit court case we have? If we send it back, that he could move to intervene and file a sworn petition under 77 and have that heard in this case?
I hesitate to speak on behalf of the department. I don't think they would like that, but whether they like it or not and whether or not he has a legal right to do it are obviously two different things. The H.B. London case, which of course is not a child support case, the party claiming an interest in the funds, and it was a third party, filed a motion to intervene within the separate action, was allowed to intervene. I believe that was without objection, of course, and then everything occurred within the garnishment proceeding. I think that there's probably a good basis for filing the motion to intervene, and just it makes sense to me to handle it all in the one case as opposed to the other case. It just makes sense to me. Follow the motion to intervene. I don't know what the department's arguments would be with regard to opposing that, candidly, Your Honor. I can't think of any offhand.
Well, if we told them they didn't have any arguments, then...
Excuse me?
I said if we told them in advance they didn't have any arguments to take, that would sort of short-circuit the discussion, wouldn't it?
I don't know if they'll like that phone call from me. But I believe there's a remedy. The statute, again, and this is the first time I've argued this particular statute, but I've argued other statutes and other rules in which it appears that the department is taking a hard line on something, and I guess to a certain extent it is, but it's really a hard line in terms of making sure that procedures are followed. We have so many of these cases throughout the state that if procedures aren't followed, it just becomes a mess. And that is really what I think occurred in this particular case. There's no bar to him proceeding, I believe, under 7716. There's just no bar to it. So, frankly, that's all he needs to do. And then I think the money's frozen is the best of my recollection. The money's not been distributed. It's still being held until this is resolved. So the money is still there. He can file his affidavit and go forward with an evidentiary hearing. And whether he chooses to seek it by an intervention and go through that, that is certainly his choice.
Saves him a filing fee.
Excuse me?
Saves him a filing fee.
Saves him a filing fee. And actually, I think the department would be reasonable. This is not something that comes up all the time with the department, to the best of my understanding. So I think in terms of efficiency, I'm hard-pressed to believe that there's going to be a big fight over allowing it to occur within this particular proceeding as opposed to filing a separate action. So we would request that the court affirm.
Okay. Thank you, Counsel.
Again, Your Honor, if you actually read the notice of intent to levy, it says that you can file in the petition in the child support case. Now,
If you're a joint owner.
well,
There's the rub.
Okay. But, you know, we've got...
Well, let me ask you this. Doesn't the statute say, maybe it's the rule, it says that the department has to give notice to joint owners? Don't they have to give notice?
Yes, yes.
How do they know who the joint owner is to give notice if they're not on the account?
That's a problem. But that's not a problem in this case, because William Green Sr. did in fact get the notice, and he filed a petition claiming the funds. So at that point...
We're trying to see the whole forest here. I mean, if they go in and they do everything they're supposed to do, and there's nobody named on the account that they have to give notice to, and, the proceeding goes along, and then somebody comes, down the pike a couple of years later and says, hey, wait a minute, I didn't get notice because I was a joint owner and they were supposed to give me notice. Do they have a argument there?
I think that if the person's name was not on the account and 2 years has passed, I think that there would be a problem. I think that the statute requires that the department gives notice if they have the information.
No, but that isn't what it says. It says they got to give notice to joint owners.
Joint owners, okay.
And I mean, it suggests to me that what they mean by joint owners is that, you know, somebody that's listed on the account, otherwise they wouldn't have any way of giving notice. Somebody that's in the circumstance of your client's father, right?
I would agree. If the circumstances that we have in this particular case had not occurred, it would only have come to the department's attention by someone contacting the department and saying, these funds are my funds. But I think the
Sounds like even if you lose the appeal, though, you got a way around it. So. Council just conceded that you can go and proceed under Chapter 77, right? You ought to do that this afternoon before you even get our opinion, right?
I've read the
I'd
argument.
be able to have the hearing before we even rule on this case.
Well, I would hope so. But my question, the problem I have with Chapter 77 is that Chapter 77 is a different scheme than this. I don't think the Department of Revenue, well, Chapter 77 goes from getting judgments against individuals and then proceeding with the.
But they already have it. They've got a child support judgment.
Yeah, they've got a child support judgment.
Right, against Mr.
But then
Green.
you also,
And I think we all agree that at least there is a presumption that the money in that account is Mr. Green Jr.'s. That's what the paperwork suggests.
that's what the paperwork would suggest.
So I don't see why Chapter 77 doesn't complement the procedure. Maybe not replace, but I don't see why the two of them can't work in tandem, as Judge Griffin has observed. But I think that Judge Torpy makes a good point that you ought to file your motion to intervene in your affidavit this afternoon, tomorrow.
Okay. I have nothing further.
Thank you.
Thank you, Counsel.